May I plead your lordship? I beg to mention item number 2, lordship. We will filing the additional affidavit, lordship, in this matter, lordship.
Okay.
So 2 weeks time may be granted.
On the prayer of Mr.
M. Hussain on behalf of RLD.
M. Hussain, learned counsel for the petitioners, raised the case after matter stands adjourned for 2 weeks.
Much obliged.
Daily list for motion. Item number 1.
Z. Hazarika, revenue. RO as for review.
May I please your lordship, 482 application lordship. Lordship will find a FIR at
482.
482
It is AB.
AB.
Mark as AB.
AB.
Cannot be 482 then.
BNSS, my lord.
Hmm?
BNSS.
Okay. BNS.
Already earlier rejected, my lord. And lordship will find a FIR at page 12. Allegation in the FIR is that, my lord, a theft incident that occurred at Ronak Enterprise Godown and some items were stolen from that Godown, my lord. That is the main allegation. And based on this allegation, section has added, my lord, 461 and 380. And in the FIR, my lord, only 3 items were specifically mentioned. But in the seizure list, page what? Page 27. Page 27, Annex 6.
Where is PP? Public prosecutor. Mr. Borua, can we have the existence of PP? Yes.
My lord, as per the FIR, 3 items were specifically mentioned as the stolen items, but in the seizure list, my lord, several items were seized from the, shown as seized from the house of the petitioner, my lord. But that items were not matched with the FIR, my lord. And on the other hand, my lord, FIR was lodged at 3.
How can you say that each battery is recovered?
Battery is recovered, my lord. That battery, which were recovered, 2 batteries were recovered, my lord, from my possession. And that
Not
battery,
two. Not two.
well, so far as the petitioner,
Not two.
as per the seizure list,
42.
yes, my lord, as per the,
42 batteries.
yes, my lord, as per the seizure list, 42 batteries were recovered.
Hmm.
And on the other hand, so far as the petitioner version is concerned, my lord, 2 batteries, which were used by them for homely use, my lord.
Also wrong. Yes, sir. Then
My lord, then, my lord, para 9, my lord, wife of the petitioner gave birth a baby.
now
On-
come to the rejection order. If it is for the second time,
Yes, my lord.
sure.
Rejection order page, Annex 3 is page 16.
You're wrong, John. Not once, twice.
Twice, my lord.
Then
This is
what
the
is the
third
ground?
This is the 3rd time, my lord.
What is the ground then?
Ground, my lord, a baby was born.
Oh, that is not the ground.
And on the other hand, my lord, FIR was, delay of the FIR is there, my lord.
After rejection, that ground cannot be taken now.
My lord, as a father, my lord, he wants to look, see his.
So you are
newborn
you have
baby,
been
my-
able to avoid everything. So you avoid. But that cannot be a ground for a review. It amounts to review. That cannot be a ground for making another application.
They can only file matter in the change of circumstances.
So this is cannot be change of circumstances.
Kind of-
Investigation, my
That
lord,
we don't know.
FIR was lodged on 23.
No, we are on our own order.
Investigation might have already been completed, my lord.
That may be a different thing.
He will
They
face
may
the
file
trial
the
and then
Final
fully
report,
cooperate with the
it is up to
investigating agency,
them,
my lord.
Mr. Counsel, it is up to them to file, submit final report or not. FIR was on 14th March 2024.
24, my lord.
So BART is in February. So I got 11 months,
11 months.
meaning thereby you have no problem.
The investigation might have already
Meeting
been
your
completed
family.
because already
In between
almost
11 months. There is no problem.
considering
In
the
meeting
one
your,
long, my
in
lord.
meeting your family members during last 11 months. That is not a problem at all for you.
My lord, seizure list is also prepared.
Hard.
If it is recovered, then already been recovered by the investigating agency.
Mr. Here is a case, then you have to go for review before the Honorable Supreme Court. They may criticize my order, that is a different thing. But so far as this court is concerned, we cannot make a review just for the birth of a child. But Mr.
MP Bora, my lord.
MP Bora, Learned Counsel for the petitioners. Then Mr. A.
RR Kaushik.
R.R. Kaushik. Learned Additional Public Prosecutor for the respondent state. Full stop. By this application. Under section 482 BNSS Pura Form to GDO 2023. The petitioner. Oh, this is Bharatiya Nagarik Surakha Sanhita 2023. The petitioner, namely Ranjan Ali, has approached this court seeking the benefit of free arrest bail, apprehending his arrest in connection with Gorsuk Police Station, case number 80 of 2024. Registered under sections 461/480 Indian Penal Code, for a third occasion, after rejection of his previous two pre-arrest bail applications, AB 1876 2024 and AB 2396 2024 by orders, dated 5/8/2024 and dated 10/9/2024, respectively, after hearing the Learned Counsel for the petition and the Learned Additional Public Prosecutor, as well as upon the perusals of the materials in the case diary, collected during the course of investigation and which were available in the case diary on those dates, full stop. Para. Page 30, not paragraph 3. Page 40, not paragraph 7. The reasons why the previous two applications, previous bail applications filed by the petitioner, were rejected, are recorded in the orders dated so and so respectively. Full stop. Para. The instant application, prepared for the third occasion in the instant previous bail application preferred for the third occasion, the petition has stated that the petitioner's wife gave birth to a baby on 22/02/2025. So, but due to apprehension of arrest in connection with Gorsuk Police Station case number 80 of 2024, the petitioner could not see his newborn baby and has not been able to perform the duties of father. First of para. The law is vessel that after rejection of an application for pre-S bail, there is scope to file a subsequent bail application for pre-arrest bail only if there is change in the fact situation or in law which requires earlier law being interfered with or where the earlier findings has become obsolete. First of para. The birth of a baby in the case in hand, the FIR was registered on 13/3/2000. FIR was lodged on 13/3/2024 in respect of an incident occurred on the same date. Also, the previous two bail applications, previous bail applications were rejected on 4/8/2024 and 10/9/2024. And those previous bail applications were rejected after consideration of the materials on merit. Post of the birth of a baby on 20 2/02/2025 cannot be. This court is not persuaded to hold a view that birth of a baby on 22/02/2025 has given rise to a new situation in respect of the incriminating materials found during the course of investigation against the petitioner. First of para. In the above PO the instant application is found bereft of any merit. Full stop. And does not require reconsideration. In view of privacy involvement of the petitioner in connection with the crime. Also, accordingly, the instant application is rejected.
Three. Item number 3.
Lordship, I'm appearing on behalf of Mr.
Yes.
DS Bhattacharya. I'm appearing in this case on behalf of DS Bhattacharya, Your Lordship. He is because of the retina operation, he could not come. I have been asked
Yes.
to make submission here in this case, Your Lordship. The present petitioners who are the stakeholder and they are running the business at the Mahamaya temple, Your Lordship. And similar petitioner, some other person has already appeared before this honorable court. They are going to initiate the eviction process without issuing any notice, Your Lordship, who are running their business in terms of the permission issued
They have
by the
served
state
notices or what?
without any notice.
Yes, Mr. Borua.
And these other 10 petitioner has already appeared before this honorable court, and honorable court has passed this order. Case 60P is the operative part of this order, Your Lordship. And the honorable court was directed to maintain status quo, Your Lordship. These petitioners are also standing in a similar footing, Your Lordship.
Yes, Burwa. They say that they are from several decades back.
Lordship, page 48 is the.
Huh?
Page
Page
48. 48.
48.
It is the order of 1973.
Whose land? Land is, the land belongs to whom?
Mahamaya Temple, Your Lordship.
Mohammed.
Mandiland, in fact, I
Huh?
remember this previous,
Yesterday-
I only appeared.
Yes.
Yesterday it was
After
listed
that-
item 44.
After that matter has been listed, so I'm not sure what development has
Hmm.
taken subsequent, because this status quo was given only for the returnable day.
Hmm.
So instruction were called for.
Yesterday it was item 44 listed, it was continued, Your Lordship.
Okay. So according to, if it is Mandir land
Lordship.
and this page 48 document
Lordship.
indicates that they were allowed to
Lordship.
shift their shops
Lordship.
below the staircase of the
Lordship.
Mohammed Ham temple.
Lordship. And that was continuing since 1973, Your
Mhm.
Lordship.
Then there should be, if there is demolition there, demolition should be preceded by some kind of notice.
Lordship.
Without any notice. If land belongs to state, then different procedure. And if the land belongs to the temple trust,
So far
and
my
what is the
knowledge was
purpose? What is the purpose for demolition?
It is
No,
with.
no, they-
For development?
No, Lordship, they have already, Lordship, and kindly
Noted.
see the page 56, 57, Your Lordship. There, a new committee was constituted, Your Lordship. There, a notification was issued on 17 February 2021.
What is the purpose for demolition? I am asking you.
They want to construct a new building, Your Lordship.
New building. New building, if that is assurance is there, then they will make it.
Right.
If they will be reallocated.
Ultimately, the district authority has come into action only on the prayer of the Mandi committee, because ultimately they wanted to go for a fresh construction for.
Right, if they have been allotted earlier,
No, that allotment has been done by committees. which-
let them, Mandi committee also come.
That agreement.
If things can be resolved in that way,
Lordship.
if they are really going to construct a new thing,
Yes.
maybe time demands that there should be reconstruction. If there is reconstruction, at least there should be allotted
Allot-
spaces, at least for running the shops since when?
1973.
1973.
73.
Heard, Mr. Al Mohan. Learn it. Counsel for the petitioner.
This year.
আপনার government advocate আছে? আগের কাছে government advocate আছে?
Mr. ZDD is yours? ZDD?
No.
BTC?
BTC, they have.
You have served copies?
Lordship.
GDD.
It is there, BTC name is showing,
BTC has been shown, but
Mhm.
GDD,
but BTC is the main authority state, district commissioner will be main. It is sub-divisional officer perhaps.
Yeah.
Mr. S. Borua, Junior Government Advocate, Assam, for the respondent number 3 and
3, 4, and 5.
3, 4 and 5.
circle of BTC.
3, 4, 3 and 4,
Only for 3.
only for 3, okay, 3. Though the name of the Learned Standing Council, BTC is reflected in the cause list. None has appeared today on call, post of para. the petitioners, comma 91 in number, comma, have approached this court by the instant writ petition, stating that they have a common cause to espouse, common cause of action to espouse. Full stop. The petitioners have stated that after initially, comma, the predecessors of the petitioners were running shops from inside the Mahamaya Dham temple. So, however, in the year pursuant to a resolution taken by the Mahamaya Dham Managing Committee on 27/3/1973, the petitioners, the predecessors of the petitioners were permitted to establish their shops from a place below the staircase of the Mahamaya Dham temple. And since then, the petitioners, predecessors of the petitioners have been running their shops from the said place. First off, the petitions are before this court, stating that on 21/11/2024, the respondent number 4, along with other officials and police personnel, came to the place and threatened to carry out demolition of the petitioner's shops. So thereafter on 22/11/2024, the respondent number 4, along with other officials and police force, carried out demolition of 5 shops. Full stop. Though due to protest of the general public, further demolition was not carried out, but the petitioners were told that there will be further demolition of the shops and eviction exercise in future. First of para, apprehending that they will be displaced. The petitioners will be displaced from the place below the staircase of the Mahamaya Dham temple, and they will be prevented from running their shops from there, which are their sources of only source of livelihood. The petitions are before this court. First of Mr. Mohan Pera, counsel for the petitioner, has submitted that ten similarly situated persons have earlier approached this court by writ petition 6437/2024. And in the said writ petition, this court had directed, by an order dated 4/12/2024, the parties to maintain, directed to maintain status quo with regard to the demolition till the next demolition by an interim order. Mr. Mohan has further submitted that the said interim order is operating as on date. Full stop. Issue notice returnable on so and so date. As MS Mr. Borua, Lineage Junior Government, Bukit Assam, has appeared and accepted notice on behalf of the respondent number 3. Issuance of formal notice to a said respondent stands displayed with extra copies within 2 working days from today. The learned counsel for the petitioner shall serve requisite number of extra copies of writ petition to the learned standing counsel, General Administration Department, and to the learned standing counsel, BTC, for the respondent number 1, and to the learned standing counsel, BTC, for the respondent number 2, 4, and 5, within 2 working days from today. The petitioner shall take steps for service of notice among the respondent number 6 by registered postal AD within 2 working days from today. Because of having regard to the projection that it is the Mohamaya, Sri Mohamaya Dham temple committee had allowed the petitioner to run their shops from the place below the staircase, and similarly situated persons have been extended protection. It is observed that in the interim that there shall not be any demolition and of the shops of the petitioner and stroke or eviction process till the returnable date.
Always lost.
Okay. Right, clear.
Seven feet. I don't know what for.
My lord, only.
Maybe too late in the day.
Yes, too late, too late. I don't know. It's up to your lordship, my lord, whether it is permissible or not, my lord, because I think stay one, there is a stay.
We can issue notice only.
Only that much. That
Heard Mr. B. Sinha, right, counsel for the petitioner. Mr. K. Cole, additional advocate general and senior standing counsel. Panchayat and Rural Development Department for the respondent number 1, 2,
4, 6.
3, 4,
1, 2,
3,
3 was it? Yes, 3.
4, 6, R. Dubey, standing counsel, Assam State Election Commission for the respondent number 5. Post of para. The petitioner is agreed by shifting of the polling station for Panchayat election to a place which is at a distance of
Nearly 10 kilometers.
nearly 10 kilometers from the household of the petitioner. The petitioner has also assailed the delimitation process carried out pursuant to a notification dated 3/8/2024 and another notification dated 15/10/2024, issue notice returnable one.
7 by
So and so, as so and so appeared, extra copies within 2 working days.
item 5.
Same ground.
Same
matlab,
thing, B
Same ground,
Sinha,
parties are different.
B Sinha, petitioners, huh? K4, 1, 2, 3, 4, and 6, R Dubey, 5. How much distance?
6 to
8 kilometer.
8 kilometers.
And same thing, 3/8/2024, 15/10/2024. Issue notice returnable same date. Extra copies 2 working days.
Oblige.
Item number 6.
May I please, your lordship?
Yes, madam, anything?
Yes, Your Lordship, we have received an instruction, Lordship. There is a land dispute. Some private party make a complaint before district commissioner. And on the basis of that complaint, field survey was conducted.
Right, but whether this, you give him a proper reply.
Then mention, Lordship.
Filed by,
Third page that is there.
for
here,
regarding,
it is
Horizontal
mentioned.
mission, Basunda, I applied for Sadhana.
তদন্ত কালত উক্ত মাটি বিবাদী বুলি জনা গল, গতিকে আবেদন নাকচ কৰে।
No, madam, we are not concerned with whether he is entitled or not entitled. That when rejecting the application, you should provide him reason. That is all we are concerned with. Whether he is eligible or not eligible, we are not concerned with.
Last page,
Which one?
page remark details, that is here. On remark column, here it is mentioned. On last portion. তদন্ত কালত উক্ত মাটি বিবাদী বুলি জনা গল, গতিকে আবেদন নাকচ কৰা হয়।
Is it available in the portal?
Yes, Lordship. Yes, ILRMS. It is portal, Lordship.
You read whether that is sufficient for him to prefer an appeal. Yes, Mr. Is it available in the portal?
Portal already, lordship, annexure 7, lordship.
I have
30.
seen, but please show him. It is, if it is in a portal.
In this regard, lordship, 26/9/2023, notice was served upon the petitioner, lordship. Accordingly, petitioner appeared before the circle officer, lordship.
No, I am asking you whether these reports are available in the portal.
Portal.
So let us read together whether it is sufficient. Abedonkari Sri Pradeep Dotto,
Amguri Rajaswa.
Amguri Rajasagar, Holguri, Mojar, Lat number 2, Joyahagar, Rajo, Gaur, 92 number, Exona Potter, 347 Nagor, Dui Bigha, হস্তান্তরিত একসনা পট্টাৰ ভূমি চৰকাৰীকৰণ ক্ৰমে পত্তন পাবৰ আবেদন কৰিছে. That is the purpose of the application.
Yes,
He has himself indicated these dark numbers and all. I like to have settlement from exonia to periodic. Let us read further. তদন্তকালত উক্ত মাটি বিবাদী বুলি জনা গ'ল গতিকে আবেদন নাকচ কৰা হ'ল দেন আবেদনকাৰী প্ৰদীপ দত্তই আমগুৰি ৰাজহ চক্ৰ হলগুৰি মৌজাৰ চয়েন্স সত্যেন্দ্ৰ আবেদন কৰিছে তদন্তকালত উক্ত মাটি বিবাদী বুলি জনা গ'ল গতিকে আবেদন নাকচ কৰা হ'ল মিনিং thereby only thing which is material is তদন্তকালত উক্ত মাটি বিবাদী বুলি জনা গ'ল গতিকে আবেদন নাকচ কৰা হ'ল that is all ultimately if we read this application particulars land details he has given in his application. What more? Same thing. It is just an Assamese translation of same thing. Come to page. Rejected by CO, possession of land is disputed. It is just an Assamese translation of the English thing. With whom it is, now you have come. Yes, Mr. Bhattacharya. What does Mohinder Pal Singh says? All this you should mention to him in the rejection order. Otherwise, appeal will be a formality only with this information. That Assamese English same, rejected by sheer possession of land is disputed. Application is rejected.
Reports are available.
Huh? Huh?
Records are available or maintained in the office of land.
That is a fault on the part of the officials, not to him. Conducted exhibition online through therefore no physical records are available, maintained available. That is the online procedure of the case as available. We have seen in today's newspaper, 2 circle officers. Is it not? Is it not? Miss, have you read the paper? It's some agogita. So with this information, how can he prefer an appeal? Appeal will be a useless formality, is it not? You provide this information with while rejecting it, you provide all this information to him so that he can prefer an effective appeal. Oh, but otherwise now it is just a formality they observe. People are landless persons looking for lands, at least they have an expectation that they should know for what reasons their application has been rejected. He claimed that 30 years he is in possession, suppose. Now suddenly with land is disputed, application rejected. That will give rise to a cause of action to serve a notice under Rule 18. Is it not? At least you treat them properly. Hard. Huh?
Not be his sampling. There may be a further direction.
It is in the Act itself. It is in the Act. Section 7. Record regions. He is statutorily obliged to record regions. So he'll go by the Act. We are not here to give sermons. Let him go by the Act. If you don't equip themselves to pass orders, but to involve in other activities, this will happen. As appeared in the newspaper today. এইটো বন্ধ হৈ গৈছে। অলপ হেৰিটো আনিবচোন, এই টেপটো আনিবচোন। টেপটো। Learned counsel for the petitioner. Do you have that particular service notification from annual patta to periodic patta? Can you find out from Miss Z. Hajorika? Standing Counsel, Revenue and Disaster Management Department for the respond number 1 and 2. Miss S. Borua and Miss S. Borua, Granite Junior Government Advocate, Assam for the respond number 2, 3, and 4. First of para. In this writ petition instituted under Article 226 of the Constitution of India, the petitioner has projected that you are also a new entrant.
Yes, Lords.
You are also new entrant. You
Lords.
entered into the land only in 2023.
Yes, Lords. As by agreement, Lords.
The petitioner has come in possession of a plot of land measuring 1 bigha, 2 katha, 10 lesa, covered by annual patta within bracket Axonia. Number 76, paragraph dag number 325, situated at Borpatro, Dole, Kalugao.
Borpatto Dole, Lords.
Huh?
Borpatto Dole, Lords.
DOLE?
Borpatto Dole, Lords.
No, I am going by your English.
Lords.
Correct or wrong?
Correct, Lords.
Huh? DOLE?
Correct, Lords.
Now I have to look elsewhere then.
Lord.
Borpatro Dol. Borpatro Dol বুলি কৈছে না। Amoja Hologuri, Amguri Avenue Circle District, Sivagar. We didn't make the subject plot. From the by UFN agreement, notary agreement, dated 10/3/2023. Which the erstwhile possessors of the subject land number 1, huh? First of, the petitioner has stated that also, or has stated that he came into possession of another plot of land measuring 2 bighas, 2 kathas, 10 lesas, covered by dag number 325 and annual patta Axonia number 76 at the same village after execution of a notary agreement dated 10/3/2023 with the previous possessors of the subject land number 2. Full stop. The petitioner stated that both the plots of land are adjacent to each other and are under the same dag number 325 and annual patta Axonia patta number 76. So after coming in possession of the said 2 plots of land measuring 4 bighas in total, the petitioner continued to be in possession of the said line, said two plots of land. Full stop. When the state government launched a scheme named Mission Vasundhara Scheme in order to streamline and resolve land related issues more accessible to public and for updation of land records, the petitioner submitted an application online under a scheme Vasundhara 2.0 on 29/3/2023 for settlement of annual patta What is the scheme? Okay. To avail the notified service, quote unquote, conversion of land from annual patta, we didn't make it AP, to periodic patta. This one, right? PP, we didn't make it PP. The petitioner has further stated that he had made application for 3 bighas of land, annual patta land for conversion, right?
Yes.
The receipt of the said application was duly acknowledged in the Seva Setu portal. Provide application reference number, page 32. On 29/3/2023. Full stop. What is the period otherwise to extend the service?
Within 300 days, Lordship. Next of 5 Lordship.
While issuing acknowledgement, comma, it was further mentioned that if the application was going to be accepted by the Revenue and Disaster Management Department, then the notified service will be provided within 300 days. Full stop. It was further mentioned that if the service was not delivered within 300 days, comma, the petitioner could prefer an appeal. Full stop. As the application submitted by the petitioner to avail the notified service came to be rejected on 26/10/2023. the petitioner is before this court challenging the rejection order dated 2016-2023. Full stop. Para. Mr. Gogoi. Counsel for the petitioner has contended that the service quote unquote conversion of land from annual patta within bracket AP to periodic patta PP is a notified service under the Assam Right to Public Services Act, 2012. Full stop. He has submitted that the section 7 of the so and so Act has cast an obligation to on the designated public servant to record regions if the notified public service is denied to an applicant. Full stop. Para Ms. Borua. Learned junior government advocate. Some appearing for the respondent was so and so has submitted, on instruction received from the respondent number 3, that there are genuine reasons for rejection of the application submitted by the petition. First of, she has submitted that she has been provided the reasons as to why the application submitted by the petitioner deserved to be rejected. First of, Para. From the
May I note, instruction received from respondent number 5.
5, Cycle Officer 5. From application acknowledgement and dated sorry, from acknowledgement. The Assam Right to Public Services Act, Para 9. Para 10. The service, quote unquote, conversion of land from annual patta AP to periodic patta PP has been declared as a notified service under the Assam Right to Public Services Act, 2012 by notification dated 14/3/2022 of the Revenue and Disaster Management within bracket Reforms Department, Government of Assam. Full stop. Conversion is a process through which status of any land settled for 1 year within bracket annual patta is changed to longer tenure. Full stop. Once the annual patta land is converted to periodic patta land, the landowner shall have a permanent, heritable and transferable right of use and occupancy in his land. Full stop. The criteria stroke conditions for conversion of annual patta land to periodic patta land have been mentioned in the notification have also been mentioned in the notification dated 14/3/2022. Post of, as per the said notification, comma, the designated public servant is the circle officer, jurisdiction is circle or officer. In case of rural areas, excluding, here circle officer rejected,
Yes, Lord.
circle officer. In respect of rural areas, excluding the area falling within radius of 15 kilometer from the boundary in case of Guwahati Municipal Corporation and 5 kilometer in case of other municipal and revenue towns. Full stop. In the case in hand, comma, the application of the petition has been rejected by the circle officer. Which circle?
Amguri circle, revenue circle.
Amguri Avenue Circle, District Sibsagar.
Lord.
Full stop. Para. The তার আগত ক্রাইটেরিয়া কন্ডিশনার এই তাতে ইয়ার পর লিখে দিব, কোড করে দিব। কোড করে দিব। প্যারা। On perusal of the impugn order rejection, it is evidently clear that the impugn order is not in conformity with section 7 within bracket 2 of the ARTPS Act. Post of para 22, para 23. Para 24, para 25. Para 22nd. Provide him the regions. We are not going into that part. If after giving the regions, if he finds himself that ineligible, he will not prefer appeal. If he finds that he is still eligible, he may prefer appeal before the other authority. But it is to be appeal.
Lord.
We are interfering because you are incapable of filing an appeal.
Lord.
That does not mean that you will come again
Lord.
before this court after the circle officer provides the regions to him.
Lord.
If I see that bypassing the provision of appeal, if you come again, this time I will impose costs. What do you say? Then civil, and he still finds he is eligible. If there is no, after analysis of the regions, if he finds that he is still eligible, he may prefer appeal. And if he finds that it is dispute, civil court, but not 226.
Lord.
A Mohindra Singh letter. Because public order publicly made should be the region. It cannot be supplemented by an affidavit subsequently filed. Here is a case. Other same.
7.
7 is
Same
also
thing.
same, Lord.
Okay,
Same
চাই পেলাই ভিতৰৰ পৰা content চাই পেলাই I'll not finalize the order today just because today is Saturday.
Item 8.
May I please?
Yes.
Lordship, in this case, husband of the petitioner had expired due to hit by an unknown vehicle, your lordship. While he was proceeding.
Yes, madam, can be disposed of.
Report is report.
Huh?
Please report.
FIR is there.
What do we do? For waiting for police report or what? Huh? Okay, issue notice. Hi, Mr. S.I. Akan, Learned Counsel for the petitioner. Ms. P.R. Mohanto. Revenue within bracket Relief and Rehabilitation and Disaster Management Department for response number 1. Ms. S. Borual and Junior Government Advocate Assam for the response number
4 and
5. Issue notice retirement 4 weeks as Ms. So-and-so appeared, accepted notice, issuance of formal notice and sequence which extra copies, we need to work in this from today. The Learned Counsel for the petitioner shall serve a copy to the Learned Standing Counsel Finance Department. We need to work in this for service of notice for response number. For service of notice upon the response number 2, we need to work in this from today.
Item number 9.
So. May I please, Lordship? Lordship, matter pertains to annual general meeting and election of GPSS Limited, Lordship. In this matter, what happens, Lordship, there is a specific statutory mandate that there shall not be dead shareholders or voters in the.
Which
Lordship.
statutory mandate, sir?
Rule 3H of the Panchayat election rules.
Panchayat
2019.
election rule, 3H.
3H.
Ah.
I have also quoted in my petition, Lordship, page 13.
Panchayat, cooperative.
Cooperative, sorry.
Ah.
Sorry, my lord. Cooperative societies election law.
What is your objection in the layman booths?
Lordship, more than we have mentioned in our representation, more than 46, Lordship. And there may be more.
All these laymen might vote for you.
Lordship, there may be more than
9 rule.
2019
Rule
rule.
আছে নেকি? Rule তো নাই। Rule ক'ৰবাত আছে নেকি?
দাদা,
They may vote for you.
there may be more than 46, Lordship. We could identify 46, Lordship, at this moment.
All 46 may vote for you.
Lordship, that is again the spirit of the rule, Lordship. 3H. Mandatory to delete them. And Lordship, we have filed representation on 27/3.
3H.
3H, Lordship.
Conduct of election. Subject to the superintendent direction and control of cooperative societies. Some following of these are the public election. The election of for constitution of board of directors to be held in a meeting of the as per section 29 by this following due. Okay,
Lordship,
huh,
kindly have a look at page 31 is the electoral rule. No date, nothing when it was published, and when prepared, nothing mentioned. Page 31, Barnacular Lordship. Only mayor's signatures and endorsement by the ERCS, Lordship, page 31.
hmm,
And no date is there of publication or any objection, nothing, Lordship.
hmm.
Only ERCS.
So this is the what, voter list?
Final voter list, shown to have been.
This
final.
is eligible voter list.
Eligible voter list. Yes, Lordship.
TH.
Yes, Lordship.
Hmm.
Lordship, last page is one,
Whose signature is there?
signature one is Lordship.
Assistant register is there.
Assistant register.
19,
Three,
3.
three, 20.
Okay, 19.3.
Page 156 is the last page, Lordship.
Page 156 last.
Last page, Lordship.
One fifty.
Same signature, Lordship.
Yes.
Secretary and assistant. register,
4,150.
Lordship, 4,156,
Huh.
Lordship, last page.
Yes.
Herein also, Lordship, assistant register put his endorsement on 19.3, Lordship.
Hmm.
No date by the secretary, when it was prepared and when published. draft
Anyway, since
Lordship.
register has signed it under his seal and signature.
Lordship. Then
Ah.
immediately thereafter, we submitted a representation next page 157, Lordship.
Ah.
On 27th, after finding this dead voters, Lordship,
Huh.
before the joint register, Lordship.
Huh.
Specifically mentioning 46 numbers of dead voters.
Assistant register has already signed it.
Lordship, we have filed before the joint register. He has the power
Hmm.
of Lordship.
How? Where from he has got the power? If it is a, suppose,
Lordship.
if it is a power, as you said, come to this rule only,
Lordship.
3H.
No.
Huh. 3A.
Lordship.
What is 41.1?
41(1) is register and other authorized Lordship officer.
41.1.
One, Lordship.
Let us see.
Lordship.
Election. The superintendent directions and the conduct of election shall vest in a register. It is duty to prepare the so and so for holding election, so and so, so and so. So this is the register,
Lordship.
41.1.
One, Lordship.
Now, by section rule 3A,
Lordship.
following officers have power to conduct election as per section 41A as delegated by the government from time to time.
Time to.
So register for state level,
Lordship.
joint register for zone level,
Lordship.
deputy register for district level,
Lordship.
and assistant register for
Subdivision
subdivision level.
level.
Your case is subdivision level.
Subdivision.
Right.
Lordship.
So once it is delegated,
Lordship.
he exercises the power of the register.
Lordship. Lordship.
Right.
Lordship. There are two provisions also. Lordship.
Huh.
Rule
Let us now understand further. So whether how zonal register is empowered.
Lordship. Rule 23 and 27.
23.
Lordship. Lordship.
Rule 23.
Lordship. Rule 23 and 27 are there.
23.
Lordship.
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 That is re-election.
Re-election at any stage, Lordship.
Okay. What is 26?
27, Lordship. That is after election, Lordship. That is
That is after election.
election dispute, Lordship.
There is election dispute.
Lordship.
Hmm.
23 is at any stage, Lordship.
Hmm.
By the
Now, who is the election authority here?
here, in this case, Lordship, election authority is the ARCS. Yes, the voter list is endorsed by himself, Lordship.
Hmm.
And we have some allegation against
Ah.
him. Lordship, that is why we have preferred before the JRCS, Lordship.
But it is the election authority.
Election authority,
But this power has been delegated to him
lordship. And
by the rule,
rule.
section 3, rule 3, small a.
Yeah, lordship.
So,
Categorization is there.
so he is the authority. He exercises the power of the registrar because of delegated
For
delegation
conducting the election.
by the state government for subdivisional level cooperative
Cooperative
societies.
society, lordship.
Yes.
Lordship.
So whether this will suffice?
And we have also submitted, lordship, kindly have a look at page, lordship, 163, lordship,
163.
of this representation continuation, lordship.
Joint register, this is 157.
163, lordship, last page.
63. This
Last
is to sign only. SN register.
Is that
Ah.
that was also received by
Ah.
lordship.
It is
Same
received.
received, lordship, same representation. We have the received copy, lordship,
Now, on 19/4,
19 from lordship.
election,
Election nomination is scheduled on 9/4, 9/4. 19/4 is the SGM, date of SGM, nomination is 9/4, lordship,
nomination is 9/4.
9/4, lordship.
Now, why you have annexed Supreme Court judgment?
Oh, that is election law is to be strictly followed, lordship.
Huh?
Please, paragraph 15, election, in case of election, this lordship. Paragraph 15, lordship,
Paragraph 15.
15, lordship. Page 177, lordship.
Now, at this stage, what? Dead man?
They may examine and delete this dead voters, lordship. in the meantime.
Yes, madam. Huh?
We have-
Please prepare election proceeding, prepare your lordship. They can move under rule 27, my lord. They has a open.
Huh?
Under rule 27.
27 what?
Dispute. Redressal of dispute, any dispute relating to the election of cooperative society may submit with 3 days from the date of declaration of the result before the election authority, my lord.
Hmm.
Things are open to them, your lordship.
Is he debarred from revisiting the voter list? If specific incidences are there, because if something is that rule 3H, then he should exercise his delegated power after deleting names of dead voters in consultation with the register of births and deaths, by inviting claims and objections. Whether claims and objections were invited? Huh? Because they have to invite for first a draft list. Thereafter, only people can identify. He doesn't know. He is a government officer. These members will know this man is dead, this man is alive, this man is dead. Whether he has to consult. If he has not consulted, let him revisit. Decide their representation, rightly or reject. Now at this stage, it is very difficult to interfere also. The process is on. Yes, but deletion of names will not affect anybody. If it is, say, 125, if deletion of name results into 100, nobody is going to be affected. If the dead men are only removed, sometimes dead men vote also. This is a problem. In MLA election, MP election, Panchayat election, nobody is going to be affected prejudicially, I think. Let him dispose of strictly in terms of rule H,
3H, lordship.
3H. Heard Mr. M.K. Hussain. Is there any private respondent, sir?
No, Lordship.
Six, your lordship, I'm not.
Who is he?
Secretary, Lordship, it will not
Ah.
affect.
He has no role. Petitioners. Miss S.T. Bok. S.T., right? Learned Council, representing Mr. S.K. Taluk. Learned Standing Council. Cooperation Department. For the respondent number 1, 2, 3, 4,
Five.
5, 6 also? Okay, 7.
Eight.
7. Returning officer?
Appointed by the ARCS, is a government official. Lordship.
Government officer. Okay,
And
7. 8 also?
8 also,
Ah.
Lordship.
Okay. In view of the nature of grievance rates, limited, in view of limited nature of grievance made in this writ petition by the petitioners, the writ petition is taken up for final consideration. The motion stays itself as agreed to by the Learned Council for the parties. First of the petitioners, 3 number are members of
Shareholders. Lordship.
shareholders of Messrs. Moidham Borkhetri Bohumukhi Homabai Committee Limited, a cooperative society registered under the provisions of the Assam Cooperative Societies Act 2007, as amended. Full stop. As the earlier board of directors of the society failed to hold the annual general meeting within the stipulated time period provided under the Act, the board of directors of the society stood automatically dissolved by operation of law prescribed in section 39 of the Act. Full stop. After dissolution of the board of directors of the society, the respondent number
4 Lords. One member.
3, by an office order dated 23/10/2024, appointed one-man management committee for the society under in exercise of powers conferred on him under section 41 within bracket C of the Act, with a further direction to the one-man management committee to perform all functions of the board and to convene the annual general meeting stroke election to the board of directors of the society and to constitute the board of directors within a period of 90 days at the cost of the society. Full stop. Para. Now, after assuming the charge, the one-man management committee proceeded to prepare the voters list proceeded to prepare a list of members with a right to vote and the list of members without the right to vote, as per the provisions of section 26 within bracket 3 of the Act. Full stop. at the stage of preparing the list of members, complaints were submitted to the effect that in the draft list of members, the names of a number of dead persons got included and the one-man management committee was represented that he should remove the names of the dead persons from the draft list. Post up. As the process leading to holding of the AGM stroke election did not progress as expected, the term of the one-man management committee was extended for a further period of 90 days by an office order dated 27/1/2025. Full stop. Para. When finally the respondent number, when finally the respondent number 4, when finally the voters, finally the list of members of the society was published under the seal and signature of the respondent number 4 on 19/3/2025. The petitioner had noticed that in the said list of members approved by the respondent number 4, the names of a number of dead persons have been included. First off, the one-man management committee has in the meantime declared, where is the notification?
We filed.
Published a notice notifying the shareholders of the society that the annual general AGM for the year 2000, the next AGM and election to the board of directors would be held on 19/4/2025. The timeline for submission of nominations to contest election for the board of directors of the society have also been notified in the meantime. Full stop. Para. As the petitioners, as it came to the notice of the petitioners that in the list of voters approved by the respondent number 4 on 19/3/2025, how many?
46 we could identify.
Names of 46 number of dead persons have been included. The petitioner stated to have represented before. The petitioner stated to have submitted representations before the respondent number 3, as well as the respondent number 4, on
27/3, Lordship.
27/3/2023.
Before notification.
that is prior to the publication of the notice on notice for election, notice for the AGM stroke election on 30/3/2025. Post of para. In this connection, comma, the provisions of rule as per the provisions of section 20, subsection 3 of section 26 of the Act and Rule 3 H of the Assam Cooperative Societies Election Rules, 2019 are of relevance and import, and the same are quoted here in below. 26, heading to take about that's 26.3 to take. But as it is a statutory mandate, on the part of the respond number 4, who has been delegated with the authority to conduct the to exercise superintendence, direction and control to conduct the election as per section 41 within bracket 1 of the Act read with Rule 3 small a of the rules, and to ensure correctness of the voters lists after deleting names of dead voters in consultation with the register of births and deaths. And representation has been submitted by the petitioners identifying.
46 number.
You have identified. Let us see.
We have mentioned, Lordship, page
Identifying 46 number of
page 28, Lordship.
identifying inclusion of stating inclusion of 46 number of dead persons in the list of voters, including their names. And what is registration number? REGN registration number.
Registration number.
And registration number, comma. This code is of the considered view that as the said representation is pending, the respondent number 4 shall take the said representation and on board and consider the same on in its own merits, consider the same after taking into account the claim and objection made by the petitioners in the said representation, and thereafter dispose of the same on merits by passing a speaking order. Post of, as the election has been notified on 19/4/2025, comma, and respondent number 4 shall complete the exercise on or before 11th of April 2025.
And petitioner may not be precluded from other rights laws.
Huh?
Other statutory rights, if appeal is preferred. Petitioner may not be debarred from.
That is up to you. With the above observations, on merits, it is further it is clarified that this court has not made any observation as regards the merits of the claim of the petitioner uh, in the writ petition, and the respondent number 4 is at liberty to consider the representation on its own merits and in accordance with law. With the above, with the observation made and direction given above, the writ petition is disposed of. There shall be no order as to cost. Part of the link. Okay, we'll come back just.
Supplementary list, item number 11.
GST cancellation.
Extension of GST registration.
Okay, we'll dispose of
Yes, sir.
the similar terms.
Yes, sir. Example. Much of it.
Okay, dispose of.
Much of it.
For implement of party, item number 10.
Implement, you want to implement whom?
Simply, respondent number 4 to 7, Lordship, there is a direction on 02/2025, Lordship, in writ petition number 6891/24.
Which order?
Order dated 05/2/2025. In writ petition number 6891/2024.
Heard, Mr.
MM Zaman, Lordship.
M.
MM
Zaman.
Zaman, Lordship.
Council Board applicant.
Yes, Lordship.
Miss G. Any objection? Z. Hajarika, Standing Council Revenue and Disaster Management Department for the opposite party number 1. And Miss S. Borua, Lanet, Junior Government Advocate Assam for the opposite party number 2 and 3. Post of the instant application is filed by the applicant seeking implement of whom?
Respondent number 4 to 7, Lordship.
Okay, the following persons, 4 to 7. As party respondent number 4 to party respondent number 7 respectively, in the connected writ petition, WPC number 6891/2024.
Lordship.
Full stop. The petitioner, sorry, the applicant as the writ petitioner has preferred the connected writ petition, WPC number 6891/2024. Seeking assailing an order dated 12/12/2024 passed by the opposite party, that's respondent number 3, and also for a direction to the opposite party number, that's respondent number 2 and 3, to issue land sale permission to the applicant, and as petitioner. First of para, it is stated in the application that the
The pair is. to be-
proposed
That's good.
party respondent are who are they?
They are the private respondent lordship. They are the respondent number 3 reject our pair for sale permission only because there is a pending case lordship.
Okay.
And this response,
It is stated in the application that the impugn order has been passed. Impugn order dated so and so has been passed by the opposite party, that's respondent number 3. In view of a pending litigation between the applicant petitioner
yes,
and the proposed party respondents.
lordship.
And in such view of the matter, their presence in the connected writ petition is necessary. Full stop. The prayer for impleadment is not opposed by the learned counsel for the official respondents. Full stop. Para. I have gone through the statements and amendments made in this in application seeking implement of the aforementioned party respondents. Aforementioned persons as party respondents in the connected writ petition. Full stop. Having gone through the statements and amendments made in this application, Command Court is of the considered view that presence of the aforementioned persons as party respondents in the connected writ petition is necessary for effective adjudication, proper and effective adjudication of the issues involved in the connected writ petition. Accordingly, the instant application is allowed. Full stop. The applicant as writ petitioner shall file an amended cross title in terms of the notification. It is so and so within 3 working days from today. And on receipt of the amended cross title, on filing of such amended cross title, the registry to cause out, carry out necessary corrections in the cross title of the connected writ petition and as well as in the CIS, and thereafter list the case for admission immediately thereafter.
Lordship.
For issuance of notice to the newly implemented party respondents.